and our first discussant. Prerna, over to you.
Hi, ma'am. It's such a pleasure to have you on the board and be a part of this discussion. Ma'am, my question is like there are various legislations for protecting women from heinous acts against them other than the Domestic Violence Act. So, why there was a need for Domestic Violence Act, or why it doesn't have edge over the other legislations?
Thank you, Prerna, for that question. Am I audible? Yeah.
Yeah.
So, as you rightly pointed out, even prior to the enactment of the DV Act, there were legislations in place which could punish an act of violence within the confines of a home, and women could seek redressal under different legislations. But if you look at the IPC, you can file a complaint for cruelty under Section 498A. It's a non-bailable provision, and most lawyers here would know that. Similarly, for maintenance, you could file an application under Section 125 for CRPC and Section 24 for the Hindu Marriage Act. And for custody, you could also proceed under different legislation such as the Hindu Adoptions and Maintenance Act. So surely there were legislations where women could seek various reliefs. But what is truly laudable about the DV Act is that it provides a single window, sort of one-stop civil remedy to put an immediate end to acts of violence against women. So now, as the law stands today, by a single application under Section 12, you can seek protection orders, residence orders, custody, maintenance, so on and so forth. So prior to 2005, no such act existed, and such a comprehensive redressal mechanism did not exist. So another, I want to talk about another unique feature of this act is the interim ex parte relief. So what does that mean? So let's say I move the court, and on the basis of the facts and circumstances I present to the court, it is possible that the court can grant me relief, believing that a prima facie case exists against the perpetrator and without having heard the opposite party. So I think that's a truly empowering and enabling provision. And so far as Section 498A is concerned, I feel a lot of women did not want to file complaints with the police and take the risk of their husbands going to jail. Perhaps that was because, they were dependent on them financially, or there was so much social stigma attached to it. And they knew that, it would mean going too far and there would be no room for reconciliation. So those behind drafting the DV Act recognize this, and now the DV law allows a woman, some room for reconciliation. Other than this, the Act also provides a meaningful and substantive idea of violence. It includes not only physical and sexual violence, as most people would understand domestic violence, but it also includes, emotional, economic, and verbal abuse. Another interesting aspect, I feel, is that of marital rape. Right? So far, the Indian law does not recognize it, but the DV Act provides some relief to women by recognizing sexual violence as a form of domestic violence. Now, I feel that this act is truly laudatory because it prohibits violence behind closed doors, and in that sense, it breaks rigid cultural barriers, right? So the act cuts across all religions, it cuts across all communities. So women of any religion, any community, regardless of her socio-economic status, can file a complaint under the DV Act and approach a court of law. Now, if you were to ask me what is the most important feature of this act, I would say it was that for the very first time, the law brought in the right of a woman to her matrimonial home, to reside in her matrimonial home. And Section 17 of the Act actually recognizes this. It says that regardless of a woman's right, title, or interest to a certain property, she would have the right to live there. So, most people understand this act as if it applies only to matrimonial homes. I want to elaborate on this aspect, and I want people to know that it also applies equally to unmarried women. Of course, married women are the victims typically, but it also applies to unmarried women. So parents, step parents, and siblings could also be perpetrators under the act. So, considering all of these features, I feel it's truly a holistic and women-centric act, very empowering. And considering all the legislations in the past, it's a really big leap forward.
Thank you
Thank
so
you,
much,
Mani.
ma'am.
Mani, do you also want to add to the fact that this Domestic Violence Act, what I find very interesting, we are still on the basics, is that it strikes a balance between the civil and criminal provisions. So largely, Domestic Violence Act has been, put forward as a civil act. So do you want to touch upon that point and perhaps explain it to our audience a little bit?
Sure. So, under the DV Act, you can't put anyone behind bars. The only time, so in essence, it's a civil remedy. The only time criminal law will come in is if the police is not acting, the protection officers are not helping out, they're not filing the DIR on time. So, in that sense, it's largely a civil remedy.
Right, right. Just moving on very quickly then to our second speaker. Harleen, over to you.
Hello, am I audible?
Yes, yes, go ahead.
So, hi Tanvi ma'am, my question is to you. So, my first question is 15 years since the Domestic Violence Act, how well do protection officers help women in need? Also, please tell us about the duties of these officers. Ma'am, we can't hear you.
Yeah, am I audible? I think it was muted.
Yes,
Yeah, you
yes,
are.
yes.
Right, right. So before moving forth with the discussion, I just briefly want to discuss that this act is wide enough. Like any woman, as being a lawyer, if any client approaches me and she says that okay, there's no physical abuse, but there are cases of verbal abuse. But there are many instances, several instances, if you tabulate, where women are reluctant to approach any authority under the DV Act because it's not a physical abuse. So, but of course, the as we are live also and many people are watching us, I just want to make this point very clear that Section 3A makes the ambit of the abuse is very clear that it includes physical abuse, sexual abuse, verbal abuse, emotional abuse, and also the economic abuse. And also the explanation part to this section describes further the inclusion of areas, so which makes it wide enough. So, moving forth with the role of the protection officer, Harleen, as you asked me. So, a protection officer is an officer appointed by the state government. Now,
Okay.
he plays a very important role in execution and also the implementation of the duties of the magistrate under the Act. So, if you see Section 9 of this Act, it defines the role of the protection officer. So, I'll try to tabulate in a manner which is, understandable to the people who've joined us. Firstly, the protection officer plays a very important role in making a domestic incident report, and then after making of this report, also then forwarding it to the, of course, to the police officer and also to the magistrate. So this is, I think, the most important role of a protection officer. Protection officer also plays a major role in providing a share household if it is required, a shelter home, I'm sorry, a shelter home, and also to make appropriate medical inquiries and also medical assistance, providing the medical assistance to the aggrieved. Not only Section 9, I think if you look in the Act, there are certain other provisions, for example, the service of notice. That's, I think, in Section 17, in Section 12. So, the service of notice, if a complaint is registered under Section 12, an application is made under Section 12, the magistrate gives the power to this officer to make the service of notice within 2 days. So this is a very important duty, I think, where the system is lagging because it describes the number of days and the duration within which this service has to be made. And so here also the protection officer plays a major role. So yeah, I mean, largely these are the duties, of course, in the act, and this is, as I said, that this is quite a diverse act in terms of if you read the definition of the aggrieved person and also the definition of domestic violence, what does it include? I think this is a very diverse legislation per se. I think that addresses your query, Harleen.
Yeah. So basically, anybody facing any form of abuse can go and seek justice, right?
Right. So, I mean, they've specified the kind of abuses, not only limited to physical abuse. I'm specifically telling this because many women are reluctant to approach or take
Yes.
any action if there's a verbal abuse or if there's an economic abuse. So, a woman is reluctant to take recourse of the act. So, it doesn't include. So, I mean, this is quite diverse, and the definition is
Yeah.
quite diverse to include the other areas as well.
Okay. Okay. So my second question to you is, can you please explain us about the process of filing a complaint and some of the practical problems with respect to the quick dispensation of justice?
Okay, are we moving with the second area right now, or is it like the?
Yeah, Tanvi, go ahead. Go ahead. You can add
All
to it.
right.
Go ahead.
Okay, okay. So, I mean, I'll briefly say that Section 12 provides for an application to be made to the magistrate. Okay,
Okay.
so a person can make an application to the magistrate. The magistrate, before taking a recourse, shall take into consideration if there's a domestic incident report that has been made. And of
Okay.
course, that again prescribes for clear duration. That is, the recourse has to be taken within 3 days, and he has to dispose of this particular case within 60 days. So I think
Okay.
this is where we need to, the system is lagging because this is, of course, has to be implemented. I was reading a recent report in which, of course, they've reported the states in which this is not followed at all. I mean, the duration and the time that they've prescribed in the act, that has to be in place and that has to be in principle and followed. So that's something that we're lacking behind in, and we have to follow this.
Yeah. Mhm. So the process which you have just told us seems quite straightforward. Is it working though in the practical life if you talk?
Right. See, as I suggested briefly, that I mean, the process per se is clear, but
Mm-hmm.
firstly, I think there are women. There are certain other areas, for example, the education, and that plays a very important role. Women are not
Yes.
educated; they don't know about the rights. So, education and also the cultural barriers, and
Mm-hmm.
also thirdly, of course, coming to the justice dispensation system, the deadlines that have been prescribed under the act, that has to be also that doesn't have to be in papers. That has to be implemented. So, in
Mm-hmm.
practice, of course, we are lacking behind. We have to take recourse, and for example, I said that the protection officer has to do service in 3 days. So in
Mm-hmm.
principle, in practice, we have to implement all of these things. So I think this is where we are lacking, and of course, I think this has to be such discussions have to be more often taking
Yes.
place because women don't know about all of these things. We are having a
Mm-hmm.
discussion, and as lawyers or as law students, we tend to know about these things. But when it comes to actual practice, then of course we have to work a lot.
Yes. Yes. Can you please tell us about the protection orders and the residence orders?
See, coming to the protection orders and residence orders,
Mm-hmm.
Tanvi, we lost your voice. I think we lost Tanvi somewhere. Maybe we can
Yes.
wait
Yes.
for Tanvi to come back. In the meantime, Shivangi, do you want to go ahead with your question for Anjana ma'am?
Yeah, sure. Good evening, everyone. I'm Shivangi. So my question is more on the judicial aspect of the DB Act. Now, like we have discussed so far, that the Act has both civil and criminal elements to it. But I want to draw your attention towards one particular section, that is Section 26. Now, this section entitles an aggrieved person to seek remedies uh, given under section 18, 19, 20, 21, and 22, which are basically protection orders, residence order, monetary relief, custody, and compensation. Now, this is often seen in domestic violence matters that simultaneous to a criminal proceeding or diverse proceedings, the aggrieved person is also seeking all these remedies. Thus, the Section 26 entitles the aggrieved person to seek these particular remedies from civil court, family court, or any criminal court. So basically, the Act widens the scope and jurisdiction of civil courts and family courts in a manner. But there is a lot of confusion with respect to power and jurisdiction of civil courts and family courts per se, and it is often seen that the aggrieved person seeks the relief under Section 12 to the magistrate and do not seek or do not invoke Section 26 enough. So my question to you, Anjana ma'am, is: has the judicial system failed in a way in implementing the DV Act effectively?
See, you can't see things in black and white actually, Shivangi. The main thing is this, that you may bring in, umpteen number of laws. But the point is, the laws don't do anything unless you change the mindset of people. So in that sense, this Domestic Violence Act has also not done something great for protection of the women. You see, the whole object of the act was this, that it would protect the women as against, the other offenses which, were perpetrated against women where the perpetrator was punished. So that punishment clause has gone where Domestic Violence Act is concerned, and now it's protection of these women. So if you say, that whether the law, whether the act or the law has helped the cause of women, I would say no. But if you say, whether the legal process has, enhanced, the chances of a woman actually getting relief from the courts or not, there I would say it is our failing. Our failing in the sense, the litigants failing, the lawyers failing, and there just one little bit of law where it has failed, I'll just point it out. If you have, Section 26 before you, if you see, relief in other suits and legal proceedings, any relief available under Sections 18, 19, 20, 21, and 22 may also be sought in any legal proceeding before a civil
Anjana ma'am,
criminal.
Anjana, I'm sorry to interrupt you, but we can't see your video and your audio is a little unclear. Can you just check your internet, ma'am?
Oh God. Let me have a look. What do I do?
Ma'am,
It
ma'am, I
says
can see you perfectly.
We're
And I
not
can
able
hear
to
you.
see you or hear you very clearly, ma'am.
I'm able to hear her quite well and see her.
Same
Even
here.
I can see her.
Ma'am, maybe you want to switch off your video and then try maybe audio, at least the audio will be clear. Or you can also log out and log back in again, ma'am, perhaps.
okay. Can you see me now? Can you hear me now?
Not
Yes,
yet, ma'am.
ma'am.
Yes, ma'am, you're perfectly fine. Please go ahead. Please go ahead. Your video and audio are clear.
Is it okay?
Yes, Anjana ma'am. Please continue.
Later on, maybe you can hear and see the recorded version of it. See, what I was saying was that when you refer to Section 26, it says any relief available under Sections 18, 19, 20, 21, and 22 may also be sought in any legal proceeding. Okay. So as soon as you say sought, it is the claimant who has to seek this relief. As we all know, magistrates and all, in any case, whenever they are empowered also, then also they don't like to, assert themselves or give the kind of relief that they should be giving. So when, the law itself says that it can be sought, it is not something that can be granted. Here, the better word would have been that it may also be granted any legal proceeding. So when it says granted, if the magistrate is sensitive enough or he's been, educated on this aspect of law, he would, a person who is a magistrate who is trying an offense under Section 498A or 125 proceedings, he would immediately grant relief also under Sections 18, 19, 20, 21 of the Domestic Violence Act. So in that respect, I would say the law is deficient. And instead of, just one minor change, of sought instead of sought, it should have been granted. Then that solve the problem. The other thing, what in my experience as a lawyer and as a judge both, it was this that when when 498A cases were usually, they were coming from the rural background. There were hardly any 498A cases from the urban areas. Now, this was, a very a striking point, because it made one think that probably the urban class women, they are more ready to succumb to any form of violence in because it adds stigma to them, whereas the rural population of women, they are more ready to speak out and fight for their rights. Now, where the Domestic Violence Act is concerned, there were absolutely no cases, which came from the rural area. Domestic Violence Act cases only came from the urban area, which meant, that the whole concept of, being protected from violence, or that a person had a right, to had a right to residence, that was, that was asserted where the urban population was concerned. Whereas I would think that it is equally important, even in the rural areas, that the women be protected and they be protected in their own residential homes. Even if it is merely a hut, then also, the fact that she has a safe roof under her head is very important. Over her head is very important. Mm-hmm. So that way, I would say the Domestic Violence Act is not acted equally, in both the areas. Now, how do we go about it? I would say that, there should be more education on this. There should be more wide publicity that this kind of a provision exists, because most of the rural population, they only file cases under Section 498A, and they get their compensation, they get a settlement, they get their monetary compensation, whatever it is, the child custody, etc., by way of a settlement. This is the usual trend. But that is not the purpose of law. I would say, that when you have to maintain peace in the society, you have to do it in accordance with law. And that law enjoins that a woman be protected in her own home and in a certain manner. And the society and the court is also obligated to do this. So it was all very easy, if there were rules which were formulated. Instead of protection officers there, you could have, ASHA workers who could be posted as protection officers. The ASHA workers have worked very well, where children's studies, etc. is concerned. At least in Bihar, I know that this is, really help where medical condition is concerned and where children's education is concerned. So you could, give additional duties to the ASHA worker as to act as protection officers. The other thing, that, you see when you look into the law, most of it says, when the respondent appears, and I have an objection to it. I was, part of a team which had gone to the US, and we studied, the working of the NGOs there. And I was especially, and in fact, all of us were especially, fascinated, at that time, because it was a very new concept that a lady could walk into the court and could take protection, order without, without anything. Just fill out her name, just fill out the form, and she would get a protection order from the court with the seal and stamp of the court. I would say when laws came to be formulated, I think there was a widespread demand that 498A was actually not serving the purpose. So that there were the parliamentary committee, etc. They'd come to Patna also, and we had sat across the table and we've given them a suggestion that this is how it should happen. That you go to the court and immediately you get a protection officer, protection order. See, no woman will go to a court, uselessly saying that she has been, brutalized, or she's been, beaten up or whatever, or she's been harassed. She would always go for for valid reasons. This is my understanding, how it happens. So if you give a protection officer, it does not harm anyone. The respondent, even if he is not heard at that point in time, it really doesn't matter. Because in case he's not ousting this woman from the house, that protection of order is in any case, is honest. It doesn't make any difference. It does not harm this man. because he's not acting, against it. So I would say, that this kind of a protection order should come automatically without, waiting for the respondent to appear for him to be heard, because he's not going to be prejudiced in any manner even if such an order is passed, in his absence. These are the two things that, I could offhandedly say, how it is disadvantageous for a woman, in any case, otherwise also, for a woman, I've seen, very bad times when I used to visit the family courts in Patna. I would see the family court officer, sitting, the judge sitting till 7 o'clock, till 8 o'clock in the evening. And, the court premises used to be full, used to be teeming, only with women. And for what? Maintenance amount of 100 rupees, 200 rupees, that kind of a thing. As I said, it was the lowest strata of the, even of the urban class, which came up and asked, for their rights. It was very rarely that a middle class woman, would ask, for maintenance.
You have very, very rightly pointed out, madam. My follow-up question was going to be on a similar note, that it is often seen that, as you said, 498A proceedings are often invoked by women from rural backgrounds, but they do not come up with the protection they are provided under the DV Act. And women who mostly go for DV Act proceedings are usually from the ones who are from financially sound backgrounds. Now, my next question to you is, what changes or what amendments, as you have pointed out the problem with the statute, what changes in the judicial system do you suggest so that the protections provided under the DV Act are accessible to women from rural backgrounds and not so financially sound backgrounds?
See, I pointed out about this rurals, if they change the rules and they made protection, if the ASHA workers into protection officers, that would serve the purpose where the rural population was concerned. Where immediate relief was concerned, I would say that protection order should be got, at the asking. There should be a form and this person should just walk in, fill up the form or get the form filled up and have the protection of order. These are the two things that I would say are important. Where the legal system is concerned, the legal system is also, you can't really fetter to some extent by the laws. So as I said, that unless the magistrate is told, that he can also suo motu, give such a relief to a person who's approaching him, he cannot do it, because it's not, the law does not say it. The law has to positively state that the magistrate is, expected to pass such an order. So when there is such a law, what will happen is, we'll obviate or, the multiplicity of proceedings that are happening just now. Actually for domestic violence or for maintenance, or sometimes for maintenance, for some other reasons, 498A cases are filed. All of us, we know this. So, all kinds of allegations are, pushed in a complaint of 498A. And when it comes to trial, these allegations, they don't hold truth, because they don't hold true. And the convictions are very rare because of this reason, because in the first place, the complaint or the FIR was not lodged for those reasons. The FIR was for completely totally different reasons, but they wanted to bring that complaint within the ambit of the law. Now, when you do that, you push certain facts which are not true. It's very difficult to prove them. And that's how, 498A cases, etc., they fail. So when DVA has come in, I think, there should have been a concerted effort to club all the cases together, as it's been done in section 26. Just with that change in the word, if it was, sought, granted, if it was granted, then the magistrate who was doing 125 matter or was doing, 498A matter would easily grant her maintenance, would easily grant her residence order, protection order, everything, compensation, medical treatment, everything that is there, custody of the child, everything would be there. So you actually reduce the pendency of cases instead of having 4 or 5, cases, which is unfortunately, profitable maybe for the lawyers, but totally against the interest of the judiciary as well as the client.
Anjana ma'am, I have a quick question as a follow up. मैम बहुत ये सवाल मैं हिंदी में करना चाहती हूँ. अंजना मैम, बहुत लोग मतलब मेरी प्रैक्टिस में मैंने देखा है कि कई बार मेरे पास मेल क्लाइंट्स आए हैं. एक पर्टिकुलर केस था. ये व्यक्ति जो था ही यूज्ड टू मेक हाउसेस, घर बनाता था मैम. मैनुअल वर्कर था, कंस्ट्रक्शन वर्कर. पर डे के हिसाब से उसको पैसा मिलता था. बहुत गरीब था. उसकी लव मैरिज थी अपनी वाइफ के साथ एंड वो डिस्ट्रिक्ट कोर्ट में आके रोने लग गया. तो मैं किसी और मैटर के लिए गई थी, तो मैंने पूछा कि सर मतलब क्या हो गया, आई आस्क्ड डीजे. तो मुझे डिस्ट्रिक्ट जज साहब ने बताया कि ये व्यक्ति का केस 2 साल से कोर्ट में चल रहा है. इसकी पत्नी ने इसको मारा भी है. इसने जब बैंक अकाउंट खुलवाया तो पत्नी के नाम पे बैंक अकाउंट खुलवाया. पत्नी जो है वो लोगों के घर पे जाके काम करती है साफ सफाई का. और अब पत्नी जब इसकी तबीयत खराब है तो उसको पैसा देने से भी मना कर रही है. तो पत्नी को चाहिए डिवोर्स. ये प्यार में पड़ा हुआ है, इसको डिवोर्स नहीं चाहिए. इसको पैसा नहीं है क्योंकि इसने बैंक अकाउंट अपने नाम पे कभी खोला ही नहीं. तो जो पर दिन के हिसाब से काम करके पैसा इकट्ठा किया वो सब बीवी के नाम पर है. और उसकी बहुत दयनीय स्थिति थी. टू ऐड टू इट, तो मैंने कहा कि सर इस पे हम उनको वकील कर दें. तो सर ने कहा कि लीगल सर्विसेज अथॉरिटी एक्ट के अंदर मैम मध्य प्रदेश गवर्नमेंट की ये पॉलिसी थी कि जो मैट्रिमोनियल मैटर्स हैं, जहां कहीं पे भी पति पत्नी इन्वॉल्व है, वहां पे फ्री लीगल एड नहीं मिलेगा क्योंकि स्टेट जो है वो घर तोड़ने का काम नहीं करना चाहती. तो जहां तक ठीक है, तो मैंने कहा कि ठीक है सर, आप मेरी परमिशन दें तो मैं इनका मैटर आर्ग्यू करना चाहूंगी. तो ये एक उदाहरण है. लेकिन बहुत सारे मेल क्लाइंट्स, मेल फ्रेंड्स ये सवाल करते हैं कि आप सब महिलाएं मिलकर जो है वो घरेलू हिंसा पे तो बात करती है, पर घरेलू हिंसा अधिनियम जो है वो केवल महिलाओं पे अत्याचार की बात करता है. तो क्या आप ये कह रही हैं कि पुरुषों में भारत में कहीं डोमेस्टिक वायलेंस होता ही नहीं? तो जब हम इक्वालिटी की बात करते हैं तो डोमेस्टिक वायलेंस में जो है वो पुरुषों के लिए भी क्यों नहीं होना चाहिए? तो मैं अपना जवाब देती हूँ, अपनी तरीके से समझाती हूँ. लेकिन यदि आप इस पे थोड़ा सा प्रकाश डालें और जो भी सुन रहे हैं उन पे आपका क्या व्यू है कि क्या भारत में घरेलू हिंसा अधिनियम में जिस प्रकार से महिलाओं को अधिकार दिया जाता है वैसे पुरुषों को भी अधिकार दिया जाए? Sevi, very quickly, I will translate for your benefit, my question that, the Domestic Violence Act is primarily for women. Should it also cover men? In the sense that if a man is a victim of domestic violence, should that be covered? This question comes to me, from all corners. So perhaps ma'am, many years of experience can perhaps explain what is the rationale behind doing it and if ma'am thinks this is justified. Anjana ma'am, over to you.
Sure. Actually, now what has happened is that people have started seeing that equality means, that there should not be any other, specific laws for women. Because if it is not for a man, it should not be for a woman. But I don't deny the fact, that women don't torture men. Because lots of times it happens, that, and I have always been, of the understanding that if a person is perverted, it is not gender related. A woman can be as perverted as a man can be as perverted as a woman. All these things, they don't actually come out, because of gender. But fact of the matter is that there are more women who face, violence than men. But now, with the exceeding, urban population and the ways in which we are leading our lives, and this is not specific only to urban. Actually, even in rural areas, there are lots of men who complain, of women torturing them and using violent methods, to appease themselves, whatever it is, So at one point in time, I think you would need certain laws which are, gender neutral. So if it violence to man, it would be violence to woman, woman to man. So, gender neutral laws that way would be much, much more welcome in the context that we're talking. But fact remains, that women do suffer a lot of violence. You may not see it, you may not hear of it, but fact is, that there is, because our mindsets are terrible, and it's all over. It's not in India alone, it's outside also. And I think outside it's worse because there is no social net, there is no emotional support, for a woman. Here, your sister may, empathize with you, your mother may do that, your father may do it, some relative will do it, even your in-laws, some of the in-laws may do it. But fact remains that women are tortured, and violent methods are used against them.
पर मैम जो महिलाएं इस कानून का दुरुपयोग करती हैं, अब
हाँ.
ऐसा कोई कानून मैम वो महिलाएं जो इस कानून का दुरुपयोग करती हैं, क्योंकि कोई भी कानून होगा तो उसका दुरुपयोग होता है, ऐसा कोई कानून नहीं बनाया जा सकता कि जिसका कभी दुरुपयोग नहीं हो। तो क्या डोमेस्टिक वायलेंस एक्ट में या उसके फंक्शनिंग में कुछ ऐसा किया और जा सकता है आपके ख्याल से कि जिससे इस कानून का दुरुपयोग कम से कम हो, या आपको लगता है कि वो चलता रहेगा एंड वी जस्ट हैव टू लिव विद इट? क्या कुछ किया जा सकता है इसका दुरुपयोग कम हो इसको इंश्योर करने के लिए?
Avni, it's a very complicated thing. To prove that it was a false case, she was falsely complaining, it is very, very, very difficult to say. Because there is a difference, As a criminal lawyer, I would say that there are lots of cases which fail not because they are untrue, also because, that person has not been able to prove its case beyond all reasonable doubt. So, there is a difference there. And therefore, to say, that any false complaint by a woman, she should also be dealt with. It is difficult to say, ki how will the law do it? In any case, it finds it difficult to deal with whatever there is. इसके बाद फिर क्या करेगा आदमी? CRPC में भी है कि any person who makes false accusation उसको आप proceed कीजिए. Have you heard of anyone being proceeded against, when there is a false allegation? लोग करते हैं, the police institutes a case, but nothing happens out of it. Nothing happens. Your final report submit करती है police, so they submit a report saying that this case is false and the informant should be proceeded against, but nothing happens, Avni. Because the court, as I said, वो तो अपना काम ही नहीं कर पा रहा, ये यहाँ कहाँ फंसेगा वो सोचता है. This is the practical aspect, of course.
ठीक बात है, ठीक बात है. Shivangi, do you have a follow-up question or should we move to Sanskriti?
Actually, I'd really like to make a point on what Anjana ma'am just said.
Yes, go ahead.
I think that this concept of equality and justice is really, really important. It's undeniable at all times that a woman can perpetrate violence against a man. I think that's globally accepted and recognized as true. But when we come to using law as a tool to give justice, we must recognize that there are multiple interpretations of equality, some of which I recognize as being quite outdated today. And law also has a duty to uphold the dignity of everyone who goes through that process. Now, when we're trying to treat everybody the same way, which would be a formal equality idea, this is that you have to give everybody the same benefit, you have to give everyone the same treatment to have equality and outcome, but that is just not how it works. If you give everybody the same treatment, the inequality that exists at the beginning will be further entrenched and actually more deeply continue to exist after that treatment is given. So globally, the shift in the last 20 years has been away from formal equality and towards substantive equality. And that's where we start to look at outcomes rather than treatment, because we recognize direct discrimination and indirect discrimination and everything else that could either happen intentionally or otherwise. And I think that intentional or otherwise part is also really important when we look at the intersection of law as it exists in a treaty or in a statute with the cultural lens that is then added to it when it's interpreted and applied in panchayats, in district courts, in supreme courts, globally. And that's something we can perhaps talk about later a little bit as well in terms of judgments not actually being just. But to come back to this point of equality and whether or not men should be given rights, I think what we need to recognize is that whilst men may be victimized and may be the recipients of abuse, it's undeniable that globally women are dispossessed of shelter and made homeless because of domestic violence. Women are harassed for dowry and for money and for male children at a rate that men just are not. Women are killed by their intimate male partners or family of their husband at a rate that men simply are not. And so what happens is if you're failing to protect women from domestic violence that happens within the home, and then you are then allowing men to be victims of that in the legal framework too, when of course they are victimized, but not at the same rate, what you risk, I think, is opening up women having a claim and a case against their husband or members of their shared household, which is then turned on them. And when we have cases from trial courts all the way to the Supreme Court of women not actually being given the legal rights that exist on paper because cultural justifications are given to deny them, then some concern has to also be raised by us and society and everyone to say, well, if you're also going to give men rights, how much can we guarantee those will also not be used against women by basically filing counter complaints? And if women are already not getting justice when they are the sole beneficiaries of a legal regime, how can we perhaps hope that they will get justice when the recipients are shared? So I think when we're thinking about who should or who should not be entitled to protection, everybody who is vulnerable should be entitled to protection. But a much more careful and deep analysis of how these legal institutions work and how they actually enshrine rights in judgments needs to be given. Because at the moment, law and the judiciary, of course, with the exception of Anjana ma'am and several other incredible lawyers and judges that do exist, but generally speaking, law is a site of injustice for more women than it is a site for justice. And the marital rape example is just one. What does it mean as a society when people in positions of power say to make marital rape a crime would be to undermine the institution of marriage? Well, what does that institution rest upon? Violence, non-consensual violence. So I think we just need to be a little careful when we're looking at how do we actually make systems effective, and giving everybody rights isn't necessarily the answer. Giving everybody rights and making it gender neutral should be a process which is deeply attached and embedded to making sure that everyone who enters into the criminal justice system has their dignity, has rights enshrined, and the judiciary is actually giving justice according to the provisions of law and not according to cultural understandings of what a just outcome is. Because when you're still operating in that latter phase, there will be hindrances to then your outcomes if you're giving them to everyone. So this is a phrase that we use quite often, this concept of law being just one piece of a jigsaw where culture is a significant part. And I think if we're going to change law to make it equal for a minority, but we're not fixing it to be equal for the majority, it will continue to be unjust. And so that question of how all of these pieces comes together becomes crucial to that debate.
There's one thing that I want to say. Is, as you said, the legal process, they also have to be, sensitive to the fact that there is equality. Now, you just have a look at this, the Bangalore case. You must have heard about this rape victim and the accused who got bail. And the reasons were this, that why did she go out with the man to drink so late in the night? And after that, why did she sleep off after the rape? Would you ask the same question of a man if he had done such a thing, if the woman was an accused? So you have to think everything is contextual. Merely saying that since, women claim to be equal, therefore there should not be any specific, there should not be any special laws for them. I think it's, a little misguided. There are, specific requirements of women, and you cannot actually deny the fact that misogyny does not exist, everywhere. Either be in the legal process, it's not only the man, it's also the women, in whose heads, misogyny is deeply embedded. So you have to get out, unless you extract yourself out of, those misogynist ideas, you cannot say that this world is equal and the woman the woman claiming to be equal must not be given any specific, rights. The point is, that have you put her on equal footing? Only if you put her on a new equal footing can you possibly say that, yes, she does not require any more, laws in her protection. But when you don't treat her as an equal, doesn't she require?
Absolutely. And I think this question of women internalizing misogyny or patriarchy is part of the problem for sure. And I think that when patriarchy is deeply embedded within society, patriarchy is currency. So the more that any individual conforms to the majority status of religion, sexual identity, gender identity, gender, however much you can conform to the most powerful people within society, the more you will be accepted. So actually, to become patriarchal as a woman also means you might be more institutionally accepted by the courts that you work in, by the government you work in, by every level of society. And so women being patriarchal is absolutely part of the problem. And I think that's where legal literacy comes in, because unless you understand the provisions of an act and unless you understand what the intent of the act is, those will never be achieved. And men can be incredible feminists. Some men are more feminist than women, and some women are more patriarchal than men. So in many ways, these sex-based distinctions are quite useless. But I think it is about politics, and it is about legal literacy in this sense, and this becomes a priority.
I think, Sevi, that's very, very well put. I mean, I can't agree more with you, and I'm so glad that both Anjana ma'am and you addressed this point, in such a nuanced way, because it's very important to drive this point home. That when the Domestic Violence Act talks about protection of women, there's a reason why that is done. At the same time, in order to make sure that that men are not victimized wrongly. For example, in India, we also have the prevention of sexual harassment at workplace. And one thing that Act provides for is that if the internal committee in any organization, which has 20 or more people and which has an internal sexual harassment committee, if it were to find that any woman has filed a wrong complaint, she can also be penalized. And it is up to the company to decide what that penalty has to be. So there are ways to check and ensure that a woman does not abuse the privilege that she's been given. But at the same time, there is a very important logic as to why we only provide for women protection under the Domestic Violence Act. So thank you so much for those inputs. And very quickly then, Sanskriti, over to you. Go ahead. But before that, Jayalakshmi, do you want to come in, or should we move ahead with the next speaker?
Yeah, I had a little question for Anjana, ma'am. I really liked where she was going with her whole part. I'd like to just ask a very minor question. Do you really think that with legal precedents, that students, like individuals, will be motivated to sort of talk about the issues that they're facing about, like despite the systemic barriers that they face? Like a good legal precedent, will that motivate individuals to talk about issues that are truly affecting them?
No, I don't think just the legal system is going to improve this. There's a lot, there are so many social stigmas attached. Unless you do a complete overall of the mindset of people, I don't think people are free to talk, just because the legal system is very efficient, therefore you can get relief and go ahead and do it. It can't be done. People will still have inhibitions. It's not only because the legal system is very convoluted or it takes very long to give you relief, therefore people don't complain. It's not that. It's the social stigma. It's the courage to stand up against the entire society, because we have a very strange notion of what a woman should be, and most people suffer from it. If you're wearing a sari, it's a typical filmy kind of a thing. If you're wearing a sari, a full sleeve blouse and all that, you're very holy. If you're wearing, a short sleeve blouse or, a short skirt, etc., then you are like a vamp and, those dark and, black and white characters. So this is what we suffer from. We have, our own, the images that we have of an ideal woman. Anybody who comes, falls short of it. We are, we jump to this, that she was the one, who did it. As I said, this judge in Bangalore, why? I mean, like, come on, why couldn't a woman, full-grown woman, why couldn't she go out and have drinks with her colleague? I mean, like, this is absurd. Why couldn't she, why wouldn't she drink? Why couldn't she go out at 12 o'clock? Because you have this concept, that women should be home, at 8 o'clock at night, before 8 o'clock, etc. These kind of things, that notions in their head. And unfortunately, women also, they like, they also see themselves, because we're so unsure of ourselves. We see ourselves in the images that others make of us. We don't have, a definite image of us. So what if I'm wearing a short skirt? It's okay, Very few people have that kind of thing. There'll still be a little bit of a doubt. whether I'm doing this correct, is this correct, is it not correct, is it approved? Because all the time, that the want for approval, the want of acceptance by the general society, because there's so much of security in strength. If everyone is wearing a sari, you wear a sari, then that you can, that people who are socially believed to be very good, and they are actually perpetrators of all kinds of crimes. It takes a lot of courage, you really, because you just stand out. It's not only the legal system is not to blame for this. Let me tell you this. Unless we all change our mindsets, nothing.
But follow up? Can I follow up?
Yeah.
Let's just quickly
Yeah,
move
yeah.
on with the conversation and then come back in the. Vishwajit wants to come in. Vishwajit, you want to go ahead and add your point?
Yes, I just wanted to say that there's a very sort of dark joke that I heard, that for if I got a penny for every time somebody said that the women, abuse the laws, I'd have 75% of a penny, because the pay gap. So the story that leads to this is that there are two things to it. One is equality, and the other is equity. And a wonderful way of telling it is that, for instance, if somebody is holding an exam and the person says, well, we'll be absolutely fair and we'll be absolutely equal to everybody appearing for this exam, all of you have to climb a tree, except that the examinees are a dolphin, a monkey, and an elephant. And that is one of the things that we must keep in mind whenever we talk about laws, being abused, laws being special for a certain section of the society. They have to be, because equity and equality are two very different things. And equality, as Sevi rightly picked up, does not necessarily translate it into being simply a case of the same thing applied for everybody. That's the first point that I wanted to make. The second point that I wanted to make is that the entire judicial process, if you look, there is never 100% conviction, even in the best of the legal systems, except maybe Korea or somewhere like that. There's never 100% conviction. So the judges and the courts are there for a reason, and the reason is that anything that is brought in wrongfully and that is taken out of the rights that are given, the judges are there to rule that out. So that has to be kept in mind. And this entire rhetoric that everybody should have equal rights, in the sense that there have to be the equal laws for everybody, I think that's completely misguided, and we need to have this special protection for certain sections.
Yeah, that's very, very well put. And I love the story, Vishwajit. Sanskriti also has some questions for you while we're at it. Sanskriti, go ahead.
Yeah, sir. So my question for you is about the living relationships. Like, what are the laws or the legal reliefs available for women who are facing domestic violence in a legal relationship?
Right. I think you mean in a live-in relationship, right? So the courts,
Yeah.
their application has been, I mean, it has been somewhat staggered, but also it says the uniformity is that if you're living in a relationship where you portray yourself as a husband and wife, whatever that means, now that is fact dependent. And there are a number of conditions. For instance, if you read the case of Indira Sarma and S.R. Batra, these are the two cases that will tell you what it means to be living as a husband and wife. So the quote unquote the gold standard is that you have to be in a married relationship, and then you can be assumed to be in a marriage relationship. And if you are in a married relationship, the act does kick in. The second thing is also you've got the case of Veluswamy, which again discusses at length. It also uses the word keep, which means somebody who is not in a rightful relationship, so to say. So that will be excluded. Having said that, as was discussed at the beginning of the panel, the DV Act in itself is one of the small things that is available. Of course, there are other remedies under the Criminal Procedure Acts, for instance, under the IPC, which can be used.
All right. So I also have another.
Go ahead. Go ahead.
I also have another question that is related to the LGBTQ. Like, we don't have any laws for the domestic violence faced by the LGBTQ. So are there any countries from where India can take inspiration Like those countries, if those countries have much more inclusive laws. So are there any such countries?
Well, I think it depends. For instance, some countries are increasingly moving towards laws, for instance, in the space of sexual harassment, which are gender neutral, because they do believe that it's not only women, it could be men, a man harassing a man, a woman harassing a man, etc. So, though there are countries that are moving towards this, I think the main thing, which I think in an ideal world would be that rather than looking at particular instances and at particular laws, I think they need to come from a scope on a space where we are talking about human rights. So human rights have to be the basis based on which these laws should be propagated. Having said that, they come with all kinds of difficulties. One of them, of course, that we've discussed being the misuse of these provisions, but there are other tensions as well which need to be discussed before we do that. As things stand, of course, the IPC sections, many of them are gender neutral, so they can be used, but some of them are gender specific. And at least as things stand in India, the remedies are not as wide as they should be. Now, there's another scheme of things which many countries are adopting. For instance, there will be laws which are specific to the LGBTQ community, for instance, hate crimes, etc. And that's really something that India perhaps should look into too, where you've got these specific categories of crimes which are done in order I mean, they're a result of you belonging to a particular community, be it religion, race, caste, or indeed sexual orientation. And that's really something that we should look on. Now, theoretically speaking, thoughts range all the way from these laws being extremely, extremely progressive to them being regressive, because there are divisions between people, and that some believe breaches the context of equality. Having said that, as we've just discussed, equality is not as black and white as some people would like it to believe. So there's definitely a case to be made. At least there should be an exploration of these concepts in meaningful and engaging ways.
Yeah, that's
Money
true.
quickly.
Yeah, I just wanted to
Second.
quickly
Money
pitch in, Vishwajit, can you hear me? I just wanted to quickly pitch in on the
Yes.
living relationships aspect. You know, you mentioned the value Swami judgment where the court used the word keep. It also went ahead and said that legislature cannot encourage premarital sex, and that it would be upon the legislature to amend the law and define the expression relationship in akin to the marriage. But there have been cases, where a woman has been in a relationship with a married man and she's also had kids. So is it not in some ways also counterproductive the way the term is being defined?
Well, my observation was purely observational. I wasn't saying whether using the word keep is right or wrong. I mean, I find it derogatory, and I don't think it should have been used in the first place. And the courts have been very, very staggered in the way they've interpreted it. So I think the closest that we've come to defining what a live-in relationship means is the fact that it has to be, of course, that you have to portray yourself as being married. Now, what exactly that means, the courts have, I think, shown some form of restraint, where they've said that this will be very, very counter. It'll be based on the factual scenarios. I think I also would like to mention the case of Khushbu, where the idea was, the discussion was whether what would be a live-in relationship, and I think she was being charged with living in somebody. The courts in every case have almost justified. They've said that regardless of what the society feels, so the courts are aware of what the society feels about live-in relationships. They are very, very clear that perhaps this is not the done thing in the Indian context. Having said that, the courts have, in their own way, tried to be, for want of a better word, liberal.
Thanks, Vishwajit.
Okay, so I have one more question.
Go ahead. Go ahead. Yes, please.
All right, so we have seen like most of the abusive marriages, they end up in divorce and the man remarries. So how can we make sure that the new wife, she is not a potential risk of getting abused again in the future? Like there are no long-term implications of the law, and if they are, so what are the certain punishments that are guaranteed by the law?
Right. Well, I think there's a very good question, which brings aspects of the width and the breadth and the length of a criminal law. One of the things is that depends on what we believe in. If we believe in, for instance, rehabilitative justice, then people can, for instance, mend their ways and become better men or better human beings, whatever we wanted to call it. So there is that tension which exists. For instance, if X in 2005 is an abusive man, but in 2010 completely transforms and becomes a non-abusive man. Now, some countries have actively worked towards it, and I think I'd like to bring in what Northern Ireland has done. So if you are in a relationship with somebody, there are two things. One is that if you're in an immediate threat or if you're in an immediate danger of violence, confidentiality goes out of the window. The government can reach out to you. The police will reach out to you, and they will ask you to make alternative arrangements because your life is at threat. The second option is, this is again from Northern Ireland, where you are not an immediate threat, but there is a possibility, and the man has been abusive in the past. There is a clear history of that with the police. That way, what can happen is that the police will give you a report upon you asking. Because there is again, this element of public safety involved here. So those are the two instances which Northern Ireland has done. But I think the bigger thing and the bigger problem that we need to see here is, number one, we don't want this law to be misused. But more importantly, we do need to have a net which balances and counterbalances confidentiality, rehabilitation, and the rights of the person who is being who has to be protected. So that's a very, very important thing that we need to talk about. We also should probably think about a register of some description, which again has to be tightly monitored. The data has to be protected very, very, very carefully. So there are ways around it, and I think this is very, very pertinent where there are instances where one man, for instance, has abused and been in about 30 or 40 odd relationships where he's always been abusive, and this could have been prevented. So I think the police, as well as the intelligence services and the courts, should look at ways of countering this.
Thank you, Vishavjeet. Thank you, Sanskriti. Let's bring in Sharanya quickly. Sharanya has a question for Sevi. Sharanya, please go ahead.
Yes, I'd like to thank and giving us a unique perspective. My first question for you is, how effective do you think provisions of the Act are in giving women rights to protect themselves from domestic violence? And additionally, how does the mindset of people affect the justice granted in cases of domestic violence?
Thank you. So I think that there are obviously two aspects to the question. The first one is related to the provisions of the Act and how effective they are. And then the next one is about how do they get interpreted when we actually get judgments. So to answer the first part, the Act is fantastic. I mean, it was extremely well drafted. It was, women's rights activists and lawyers for decades of worth of experience contributed to this Act. And it's extremely sensitive to the needs of potential domestic violence victims, survivors. And I think that that's the most essential thing that I really admire about this piece of legislation, is that it consulted people who were affected, and it engaged with activists and lawyers who've been working for women's rights for decades to then decide what would be the most appropriate form of legal redress. And one of the most obvious things is it's a civil remedy. So if you are living with someone, either alone or in a shared matrimonial household, you are perhaps dependent upon them for your income, for your shelter, for your survival, which many women are when lower literacy rates, lower enrollment at education, lower employment prospects, lower employment prospects in positions of seniority and responsibility making positions is true across the world, but perhaps amplified in countries like India, then you do get a level of dependence of women on men. And I think in addition to that, which is a global truth, we also have this extra element where a lot of the time a woman's status is dependent upon her marriage and her husband in a lot of many parts of India. So with that in mind, this was not a criminal piece of law. It was a civil piece of legislation that, as we've talked about already, has the right to reside in a shared household, has a protection order, has a residence order, has the right to claim maintenance. And then if you get these maintenance and other orders from the court, Should that order be violated, you could argue it becomes contempt of court and it becomes a criminal provision, which you could then take back to court with a level of, something that the respondent would want to avoid because of the potential sanctions attached to it. So I think that when we're thinking of these protection orders and residence orders, the residence order is even to a room in the house that would be safe for that woman to, and possibly her children, to then live in. So she's not even expected to continue living in the same room as an abusive partner. So in that sense, the provisions are excellent. They enable her to continue living in the marital home. They enable her to have some legal remedies such as protection orders put in place to protect against future violence. And they also make this concept that if that order is violated, there's a backup mechanism where you can immediately go back and approach the court. So for me, the provisions are actually wonderful, because you could go on living in that shared home with these legal protections in place to secure your health, your well-being, your safety, and also your financial ability to live and buy food and everything else that you need. The issue becomes when people try to now exercise their legal rights and have these enforced. Because what we see across the board, I've seen it in panchayats, I've seen it in trial courts, and obviously we all see Supreme Court decisions all the time, is that this cultural lens gets applied onto these legal provisions. And instead of a transliteration process going from these are your rights to this is what we think you're entitled to, this think changes everything. So when Vishavjeet earlier on was talking about derogatory language, it's not just derogatory language that's used. And Anjana Ma'am was talking about this victim blaming of what were you doing, out drinking at night with your friends or with a man. This victim blaming, this kind of inbuilt misogyny becomes totally influential. So in a study of more than 50 decisions and judgments from the trial court in Sonipat, what I saw was that in 80 to 90% of the cases where women had asked for a residence order in the shared home and an amount of maintenance, the residence orders were denied and the amount of maintenance was lowered quite significantly and ordered to be used to pay for rent. So this woman could go and rent somewhere to live alone. Well, living alone is not necessarily a safe situation for a lot of women to be in. And it also places significant financial vulnerabilities on that person, because if the husband fails to pay the maintenance, she can then not pay her rent. So where might she live? And there are already reasons why she's not returning to her parents' house, because it's not necessarily something that is either culturally appropriate or something that she wants to do. And in the UK, one of the leading causes of homelessness for women is domestic violence. So we can assume that there's a level of similarity here between jurisdictions where if women are not earning or are not earning as much as men, if women are responsible for looking after their children, for feeding and clothing and educating their children, their costs are more. And then you're still expecting them to live alone and live alone safely. So homelessness becomes a problem. And then what happens when the cost of real estate increases over time? What happens with inflation? What happens in retirement? What happens in the case of bereavement if the husband passes away? So when you're not giving a woman a right to live in the shared household, which she is asking for and legally entitled to according to the provisions of the Act, the situation is you are potentially making her much more vulnerable, both in the short term as well as in the long term. And I think this is one of the biggest problems. Women are not getting the rights that they're entitled to when they go to court. Instead, they're getting a judgment that the judges think is appropriate and also an easy solution. And it's not appropriate. So again, what are we thinking about when we think about mindset? What are we thinking about when we think of justice? I'm sorry, I can't remember who, but earlier on in the discussion, somebody mentioned in the case of not quite live-in relationships, but what happens if a woman has a relationship with a married man and then goes on to have children? Well, that's not really a domestic violence issue. That's an alimony child maintenance issue. But bigamy is something that I came across in the cases and the judgments I read. And one of the cases was a woman lives with her husband after marriage and his relatives. She is subjected to what she called merciless beatings, filthy language, demands for dowry. To counter that, he accused her of being a quarrelsome lady, the violence became so extreme that she went to go and live with her parents. She was already pregnant when she did that. She had a child. When she bore her child, she wanted to go back to her husband's house, and for all the reasons we can probably already imagine. And she found out he had converted to another religion and married somebody else. So she goes to court and she says, he is my legally wedded husband. Here is my marriage certificate. Here is the fact I have a child with him. Here are photographs of our marriage. His marriage is undeniable. And yet the court's response is not that he illegally married somebody else and is now cohabiting with her, and she does have legal rights to access to the shared household, access to maintenance, and access to everything else. And instead the court says, you're quarrelsome. That is not conducive to a happy marriage. He's happily married to somebody else now. Let's let that marriage be happy. You go. And so what happens to her legal rights? Nothing. She's effectively left rightless. And so what does justice mean when you're not able to effectively realize your legal rights? And you are in fact subjected to the cost of a judicial process because you have to travel to and from the court. You're subjected to the costs of litigation. You're subjected to humiliation and indignity in terms of having to go through this process and not getting a remedy that you are entitled to. So when we're thinking about justice, I think we need to first of all recognize that there is a significant gap in the legal rights women are entitled to and their actual realization, both in judgments and in effective realization of those judgments. So something that a lot of research is finds it very difficult to do is go, well, how many of these positive judgments, which in themselves are not very many, actually get implemented, and how many only exist on paper? So I think when we're thinking about vulnerability, this is something that we really, really need to think about more. The second thing is that when we're thinking about this justice gap and we're questioning what does justice mean, we need to recognize that no theory of either justice or injustice should ever be considered complete unless you are asking victims and survivors and complainants, what would justice mean for you? And that doesn't always mean, in the cases of gender-based crimes, a punishment or a conviction. So women are not accessing criminal law provisions that already exist regarding cruelty, regarding violence, regarding divorce, because they don't want them. And that's either because they don't see that as being a just outcome, or it's because they don't want to be imprisoning potentially someone they are dependent upon. And so what would a more just outcome look like for that complainant? And we start to see a whole multitude of possibilities. It could be admission of guilt. Domestic violence is not okay. To physically, sexually, emotionally, psychologically, financially abuse someone is not morally or legally acceptable. And there has to be recognition of that event. There needs to be some kind of redress. So what will that promise be to ensure it doesn't happen again? Should there be recognition of moral injury, that you consented to marry someone, but now you're treating them in a certain way that you should not treat your partner? How do we get recognition for that crime or that act? And how can you prevent it from happening again in the future? And I think this reform of behavior and prevention of future violations is what a lot of women approaching courts would see as the most desirable outcome. And that is just not happening. So this is one of the biggest problems when we question what justice is and whether or not it's granted.
That's very, very well put, Sevi. And we have 10 minutes, and I'm sure there are speakers who want to make more points. But just to kind of make sure that we have 10 minutes before we wrap up for today. But Sevi, I have a question, particularly with what's happening in India right now. Maybe you can tell us what's happening in UK and if there's a better way to do it, if you have a comparative perspective. And other speakers, please feel free to add to it. Now, since the COVID-19 pandemic has begun in India, we have seen a tremendous rise in the complaints of domestic violence cases with the National Commission of Women. Now, I personally wrote a letter to the National Commission of Women requesting that, a series of measures be taken, drawing from the best practices around the world, having Domestic Violence Act and talking about in its implementation in normal times is one thing, but especially during the lockdown, what could we do? And I suggested a series of measures. But my question to you is, in terms of the positive obligation on state to take care of some of these practical difficulties and address the domestic violence issues, as long as this lockdown or the pandemic continues, which is, not the normal situation for the for talking about the implementation of the act. Do you have suggestions, ideas that you're seeing elsewhere in the world, and you think this is what probably something to discuss and debate about? And I request other speakers to please come in if they think there's something that the National Commission of Women or the Women Ministry could take into consideration even at this point. Sevi, over to you, and then Vishavjeet, please feel free to add on.
Thank you. It's an excellent question and an enormous one to try and answer in a few minutes. The short answer is this is a global problem. There are best practices that we can identify and try to emulate, but essentially very, very similar to what Anjana ma'am was saying earlier. Women need a safe roof over their head. They need to not fear violence. If you fear someone is going to physically or verbally or in any way abuse you every day, every time they lose their temper, every time something is banged against a wall, there are deep, deep psychological traumatic consequences to that will be felt for years to come, and will also be felt by other members of the family, especially children. In recognition of that, the UK has actually recently changed or introduced a domestic violence bill 2020. And this is firmly rooted within what they call the public sector equality duty. So if a state and state organs such as the police, the judiciary, local government, local councils are acting in a way that will negatively, disproportionately affect women, then women are being directly or indirectly discriminated against. And to redress that is a public sector equality duty. The same would apply in India by virtue of your constitutional law to equality, to dignity, to right to life, and so on. You could also look at international human rights law instruments. Now, despite the international laws guaranteeing equality and non-discrimination that have been enforced, even in India for decades, discrimination and inequality continue to exist all of the time. So I think that you really have two issues here. Number one, housing. Women are made homeless because of domestic violence all of the time. So do local governments and councils have a statutory duty to be ensuring access to safe houses? The answer is, of course, yes. Are women failing to get decisions that they should be getting when they go to court to seek maintenance all of the time? The answer is yes. There's an NGO in the UK called the Centre for Women's Justice, and they're phenomenal. Now, last year, they filed a super inquiry against the police in England and Wales, and they alleged essentially four things. And they said, as a police force, you are consistently failing to impose bail conditions on men who have been accused of violence. You are consistently failing to use domestic violence protection orders, and you are consistently failing to implement and exercise violations of restraining orders. And so if you're not imposing bail conditions, you're not issuing domestic violence protection orders, you're not executing violations of a restraining order, then you are leaving women and their children much, much more vulnerable, not only to the initial abuse, but follow-up subsequent abuse, which may be in retaliation for police complaints to be made. And globally, we recognize that two of the most dangerous points in an abusive relationship is the point of leaving, 1 year after leaving, and pregnancy and childbirth. So this is when homicide is most likely to occur. We also have a national police force which has been saying they want to tackle knife crime. But the public discourse surrounding knife crime is almost exclusively targeted around teenage, mostly male gang behavior. But one of the most leading causes of death for women is homicide. Around 40% of violence against women takes place in the home, and a lot of that involves stabbing. So there was a very famous case of Joanna Michaels, who was stabbed to death more than 27 times, and she had more than 100 injuries on her body. So why are crimes against women not part of this dominant narrative. Now that's beginning to change. The Mayor of London and several other police forces in the UK are now increasingly talking about making misogyny a hate crime. And similar to the conversation earlier on regarding recognition of sexual minorities, in the UK, harassment laws and domestic violence laws do not exclusively protect women. They protect people on a series of protected characteristics, and these include your gender, your sex, gender reassignment, and sexual orientation. And I think that's really important to recognize all of these different forms of vulnerability. We also know that people who have long-term illness or who are registered disabled are also much more likely to not be able to leave abusive relationships. And so therefore special attention needs to be given to them. So my final point regarding what can we actually do to go forward is exactly what Anjana said. We do not need more law. Your constitution was founded decades ago and it has equality and non-discrimination and right to life with dignity within it already. What we need a new lens to look at that law, and we need more attention to what does dignity and what would justice look like. Because women, in 2007, 2008, I was working with panchayats in Himachal Pradesh 1 year after the DV Act came into force. Women know what violence is. They might not know what their legal rights are, but they know what violence is. They know what injustice is. They know what it is to have their dignity taken away from them. But when they go to the panchayat, what happens is the Panchayati Raj members are not trained on justice. We have a whole act on crimes cognizable by a panchayat. And most of the panchayat members only know about regional development work, economic improvements, sanitary improvements, and they're given about half a day training for their entire tenure as a panchayat member on justice. And there are land issues, and there are theft issues, and there are so many other issues that gender rights just kind of falls down that ladder of priority need. And so you constantly get systems relying on this concept of samjhota or compromise. Basically, this is what we think will be a great outcome according to our mindsets. And it's unfortunate that most of the elected members are normally men. And so you don't get this feminist voice of lived experience to say, actually, no, that's not what justice could or even should be. So I think we really need to look at how can we change that? And for me, the biggest thing that we need an effective monitoring and accountability mechanism. When the Supreme Court of India says that the Domestic Violence Act is the result of clumsy drafting, that should not be acceptable. There should be something that, holds those judges to account. And this is, of course, a reference to the Taruna Batra case when she was trying to get access to a shared household, which was effectively dismissed. And it's not just domestic violence. These are not isolated cases. This is a pattern of discrimination on the basis of gender. It's the same for sexual harassment. It's the same for sexual violence. Avni, earlier you mentioned the provision in the Sexual Harassment Act that says, false complainants will be met with a punishment. Which other piece of legislation has a provision for false complainants? None. There is just this assumption that we can blame women, which is just incorrect. So I think believing women has to be the starting point. Training judges and lawyers and everybody else about what law already exists has to be a starting point. And holding people to account for failure to implement what they're legally and morally bound to do has to be the end.
Yeah, Sevi, I think your point about legal literacy is a very important one, and something that I think we will be discussing also in our next session when we talk specifically about implementation and enforcement challenges around domestic violence. So we will make sure to pick that as a theme and discuss it, a little bit more in detail. Vishavjeet wants to make a point, and then Mani, and then finally to Anjana.
Right,
Please go ahead.
I'll be very quick. Just to what Sevi's just said, I think we need to remember that India as a country, and this might be true of other countries as well, but especially India, I think we are living in several centuries at the same time. And I have had cases where, people have actually asked me, for instance, I was actually asked by a woman, if the man only slaps her and doesn't break her arms, is there still violence? Equally, there are other surveys which was done, I think, by the Quint, where about 7 or 8 out of 10 people they are in Haryana, they blame women if they are raped to the extent, and it's actually sickening to watch where little school children, they are asked, they said, what do you think of rape? And their answer is, well, if a woman is, or if not even a woman, if a girl is wearing trousers or skirts, then it could be blamed on her. So I think this mindset has to completely change. How we do it and where we begin really needs to be the discussion. I think laws that are passed many times are knee-jerk reactions to problems which are massively, massively bigger than any law alone can solve. So there has to be a conversation which is open and which is also wholesome. And I borrow from Shakespeare just to to say the final word, that my words go up, my thoughts remain below. Words without thought never to heaven go. And we really need to put in this thought. Thank you.
That's very, very well put. Thank you, Vishavjeet, for that. Mani, and then Anjana ma'am for your final comments, observations.
Right. Thanks, Avni. So I just wanted to point out, that the law, as progressive as it may be, there are certain ambiguities and loopholes that, certainly need to be addressed. If you look at certain judgments, for example, the Harbans Lal Malik judgment, it's, I think, of the Delhi High Court from 2010. It goes on to define a joint family, and it says things like, essential features of a joint family are whether all decisions are made by a head male of the family, or income and expenditure are in the common pool, or whether they, eat at the same dining table. And, such interpretation of the term joint family leaves so much room for confusion. And this is perhaps the reason there is so much conundrum around it. Even the S.R. Batra judgment, like if you were to ask me, I feel that, it went against the letter and the spirit of the law when it said that a daughter-in-law would have no right to a house exclusively owned by her in-laws. And if her husband has no independent right in such a house, she would be evicted from it. I mean, there are courts that have deviated from S.R. Batra, which is, a very optimistic deviation. But really, Taruna Batra is a case which, left so many women in distress and without any remedy. So this goes a long way to show, that even if the legislature enacts a law with a view to bring equality, its ultimate success is, of course, dependent on the judiciary. As Sevi and Anjana ma'am have pointed out, mindsets need to be changed also.
Right. Thank you, Mani. I think what you're pointing out about the joint family is a very interesting point. It's also something to touch upon the language of the law, right? That if the language itself, uses men and women in that kind of a binary fashion, reinforcing stereotypes, then what else and what better do you expect from common people who are reading those judgments and interpreting it? Anjana ma'am, over to you for the final word for today's conversation.
My final words, there can never be a final word, Avni. We are a continuous process, and unfortunately, we have to accept, that we're living in an unequal world, and we need to make it equal. And this is not only a woman's job, I think every man also needs to be sensitized. As Vishavjeet said, that a man also has to be sensitized to the requirement of placing a woman as an equal, neither as a Devi nor as, somebody who's subordinate. And all these concepts, these very romantic concepts of family and, an ideal woman and all that, all these things need to change. We need to develop ourselves, we need to develop and understand, that what is wrong and what is right, in a context. Some things may have been good, at one particular point in time, but it cannot be good, for all times. So we need to change as the society changes. And unless, we make positive efforts, I don't think, there has to be a conscious effort at all times that, you need to acknowledge that women are equal. And you have to demand it also. A woman also has to, a man has to give, whatever, has to understand that a woman's, demands are very valid. They're not special needs. Just because she's, she claims to be an equal doesn't mean, that she does not need specific laws. The fact is that she's not treated as an equal. And unless she's treated as an equal, you should not have the right to ask question that the question, the fact that women still need specific laws for their protection. That's about it. Thank you.
Discussants, any final pressing points any of you want to make very quickly? Unfortunately, we are up for time for questions, but any pressing points you want to make as your last comments to the conversation?
I have one last comment.
Yes.
I really liked what Anjana ma'am said regarding women need to be demanding their rights. And I think that the only thing we really haven't explored yet today that I think is important is that when women are going to courts and they are demanding their rights, one of the biggest problems I saw in Sonipat was that the judges want to be neutral. So they're saying we're only going to pass judgment on the evidence presented before us. And the woman is saying his income is this much, I therefore want that much maintenance. But she is unable to prove his income. And so then basically the court say, you're alleging his income is this, he is alleging his income is this, we will basically find a number between those two that we find to be agreeable, and we will then give you maintenance of 2, 3, 4,000 rupees a month. The courts are not using their powers to actually ask or subpoena documents from employers, from bank records, from title deeds, from anything else. And so when you have a woman who enters her husband's family or home upon marriage and is then having domestic violence issues with him, it is just unrealistic for her to be able to request the title deeds for land and property and businesses and assets from her husband or her father-in-law, or to be able to get documents proving his income. So the courts actually are not being neutral. In the face of complete inequality, to be neutral is actually to give power to the most powerful party in that. And so I think when we're thinking about what is the role of magistrates, I think the role of magistrates should be find out exactly how much income he has, find out exactly how many businesses or how much land he has, then make an assumption on his income based on that. Because unless they start trying to rebalance this inequality, the inequality will persist and law will continue to fail women in trying to access their rights.
I think the role of the magistrates, especially in the Indian scenario, Sevi, is more important, I would say. I mean, it's important in every country, but especially in a country like India, where a lot of people are not aware of their rights. I mean, they're not that keen to go to the courts in the first place. So until I think, magistrates and judiciary members are trained and sensitized to these issues, there will continue to be a gap between what the law says and what the implementation is. Well, I think today's conversation has been riveting, and there is no way, as Anjana ma'am said, to have a final word on it or to be able to summarize it in a way that covers everything that all of you have presented. But I do hear two things standing out very, very clearly. I think Sevi said it exactly like that at some point in the conversation. That do we have a good law on domestic violence in India? The answer is absolutely yes. But do we think that there remains a huge gap in terms of its implementation? The answer to that is also, as Sevi said and other speakers agree, is yes. So we hope the MOVE and Project Raahat that this series of ongoing conversations will help plug in more and more people into this conversation, not just experts, not just lawyers, not just psychologists, sociologists, NGOs, but individual common people who may be facing domestic violence as a sad reality of their life. A big thank you to all the panelists, to all the discussants, everybody who took out time to join us today's conversation. We were live on the WOM's YouTube page and the Facebook page. We are a growing organization. We are about 2 months old now in the public domain. So we're very, very happy that we were able to bring all of you together and for you to give us your time with so much liberty, and we're very, very grateful for that. This conversation will be continued, and we hope everybody who is tuned in will tune in back next Sunday, same time, 4 to 5:30, where we'll talk about specifically the enforcement and implementation challenges around domestic violence. Thank you, everybody. Stay safe. Just a final word, anybody who has a legal question on Domestic Violence Act, please know that National Commission of Women's website is there, which provides a helpline. यदि आप किसी प्रकार से भी घरेलू हिंसा का शिकार हैं, तो गूगल पे जाकर आपको सिर्फ नेशनल कमीशन ऑफ वुमेन हेल्पलाइन नंबर टाइप करना है. वो व्हाट्सएप पे भी काम करता है, और यदि आप नेशनल कमीशन ऑफ वुमेन को लिखते हैं तो उनका टीम आपके पास वापस आएगा और आपकी प्रॉब्लम सॉल्व करने की कोशिश करेगा. एंड इवन वी शुडंट put all the burden on National Commission of Women. There are lawyers, there is Vishavjeet, there is Mani, there is Anjana ma'am, I am here. We have a lot of young lawyers on board. यदि आप में से किसी को कोई भी समस्या है, if any of you face any trouble, please know that there are people who are willing to help you out. You're not alone in this battle. Thank you very much and have a good evening. Thank you.
Bye. Thank you. Thank you.
Thank you,
Bye.
everyone. Bye. Thank you, everyone.
Bye.